Good morning, everyone. The Committee on the Revision of the Penal Code is back in session. I'm going to wait a few seconds to let the audience log on, and then we will get started. Okay. Welcome, everyone. Thank you for this continuation, for everybody for coming back, for this continuation of our hearing from yesterday, which I thought was quite productive. Let me just say a couple of opening remarks before we get started. First of all, I wanted for everybody, members, but also members of the public, to understand and appreciate that we've embarked on this journey to revise the penal code. And sometimes I refer to this metaphor of a boat, that we know that the boat is has extreme problems and perhaps is sinking. And there's a question about, are we just patching the boat, or are we creating a whole new boat? And I think that this year, our first year, and in light of COVID, and that this is a boat patching process as much as anything. And we've tried to find the biggest leaks, not to extend the metaphor too far, and where there's the most consensus, and correct those problems to the best we can. I do appreciate, I hope everyone appreciates this is our first year, it's an extraordinary year amount of COVID. And also we're dedicated for the bigger reforms and for the future to really have our recommendations based as much as possible on really concrete data. And that data is beginning to come in and to being compiled in a really rigorous way. And we'll have much better and more rigorous data and robust data in the years to come. So I just wanted to say that. I also wanted to say, number two is, obviously these are public meetings. Everybody who's testified and testifies know that they're public meetings. Many are public officials. And I understand that there are some people on social media that have picked up on what we're doing, which we very much appreciate, and we want to have a public dialogue. It's one of the reasons why we have public comment at the end of this. We also receive lots of emails and we want to respond, and we appreciate that. There are a lot of strong feelings on the issue, many of the issues that we're touching on. But I hope that those of us who follow us closely realize that this has really been a year-long conversation with hours and hours of a testimony and conversation with over 70 witnesses. And sometimes, obviously, those are hard to distill into tweets, and just if we could appreciate the context. And I think for the most part, we're trying to all row together. So with that said, for today's business, we left with really three outstanding items. One is to get to proposal number 10, which is where I would like to start our conversation. This is about second look sentencing and 1170D. I'm about to restart the slideshow. And then we will circle back to the two items that we did not reach a consensus on yesterday. Those were about judicial discretion under 1385. That was proposal number 5. And then judicial review of parole decisions. That's proposal number 9. I will make the slides. I will draw everybody's attention to the slides as we get to them. Sound good? All right. So let me try sharing my screen. All right, can people see that? Okay. I'm just organizing my screen a little bit. Sorry.
That's where I got our sandwiches.
Excuse me. Okay. So this is the proposal that we discussed at our last meeting with witnesses. It is the 10th out of 10 proposals that the committee has identified as priorities. And this relates primarily to Penal Code 1170 D1, which currently allows the CDCR, Board of Parole hearings, and district attorneys to send folks back for resentencing consideration. And that basically gives the courts authority to start from status quo ante and resentence somebody or not resentence somebody in their discretion. Currently, defendants cannot request resentencing on their own. And perhaps most problematically, as we heard from our witnesses, is there's no process specified in the statute about how these requests should be handled. Many go ignored completely. In fact, we believe most of them have actually been ignored through sometimes lack of understanding of what the statute's about, sometimes just pure bureaucratic, things get lost in the shuffle. So the proposal was to specify greater process to ensure that resentencing requests are heard by the courts and both parties have an adequate opportunity to respond. To create a resentencing presumption when those recommendations are made by law enforcement. And then finally, there was a suggestion that we should discuss about allowing defendants to request their own revisit resentencing. And this is borrowing from the federal bill proposed by Senator Cory Booker in Congress. So to get to the specifics, number one, if resentencing, we've divided, there's a number of ways that courts, that the cases can come back on resentencing. And we've separated them out because I think that they're important different categories. If a resentencing request is made by, is from law enforcement based on meritorious conduct, and that the law enforcement specifies that this is based on meritorious conduct, then we require notice and initial conference within 60 days and appointment of counsel. Second, we create a presumption favoring that recommendation. Again, if it's coming from law enforcement and based on meritorious conduct. And then three, require written reasons for the court decisions one way or another. People have comments, thoughts on number one?
Do we need the written reasons? I'm only thinking that maybe we only need the written reasons for denial.
A written reason for a grant would be a resentence, and that would kind of be required automatically. Judges, I'm going to refer to you. You can't just waive your one and say you're resentenced. There has to be a resentencing proceeding. Maybe that's implicit and we could make it explicit, but what do you, judges, what do you think?
Sorry, I was distracted for a moment, but if the issue is regarding notice, I think that the prosecution's going to need notice, if
Yes,
that's the question.
The question is not about notice. The question is about for written reasons for court decisions. Do we need a written reason if they're going to grant the petition? Or is that just part of the resentencing process?
I think you do either way, for denial or granting. I mean, you need a reasoned decision one way or the other.
I agree.
And just so we're formal, just so we're aware of what that means, this does not require a written lengthy opinion. This can be recorded in the minutes, just like
Sure.
other explanations from judges. It just can't be a denied period.
Right.
Stop.
Now, is it best to leave the meritorious conduct without any kind of definition? It could be cooperation in an ongoing investigation or just about anything, I would think.
Correct. So CDCR, which is currently the only agency that's really doing this at all, has a very strict regulations about what constitute meritorious conduct. So those are quite clear. The BPH has so far issued 0, and prosecutors have issued a dozen, maybe statewide.
Yeah.
So we should probably indicate that if they want this presumption, they should use the words meritorious conduct. That's borrowing language from CDCR. And then they
Right.
can, if this is coming from a law enforcement agency, we will defer to their opinion on what meritorious conduct means.
Right.
Okay. Everybody okay with that?
Well, yes.
Okay, number 2. Now, there's a number of resentencing requests that coming from CDCR that are not necessarily based on meritorious conduct, but instead are based on the fact that there's been a change in law. In fact, that's the majority of cases that are being sent back by CDCR. They're saying there's a change in law. It doesn't necessarily apply retroactively, but we want your honors to take a second look because before you didn't have a chance and now there's been a change in law. So our proposal is if it's based on a change of law that is not meritorious conduct, or perhaps if it's just silent, then again, require notice, an opportunity for written decisions. We would not require appointment of counsel necessarily. And courts may grant or deny the proposal for any reason rationally related to sentencing. That rationally related to sentencing is taken, it's a direct quote, should be in quotation marks, from a case called People versus Dix or In re Dix, a California Supreme Court case on how you're supposed to handle 1170D cases anyway. So that would be no change in law. That would just be sort of codifying Dix. The change between number 1 and number 2 is we're not requiring appointment of counsel and no presumption.
Can we, go ahead.
No, please go ahead, Judge Espinoza.
Can we insert language that says that trial counsel shall be given notice? Not that they
Yeah.
be reappointed?
Require note, that's the first check mark, require notice and opportunity.
Okay, so that includes previous counsel.
Yeah, we should be clear about what previous counsel is. This is part of the problem that CDCR has had. Let's say you've been sentenced 10 years ago. The public defender does not consider itself previous counsel anymore because there's been an appellate attorney being the most recent counsel. So I think that maybe we say counsel to require notice to the public defender, chief public defender or something like that to get somebody's attention, because this has been a significant problem.
Yeah.
Current notice has gone to the last public defender. And in many cases, these are 20-year-old cases. Those public defenders are no longer there. They go to a mailroom to some long retired or dead public defender. So I would say specify to the public defender office or something like that. Senator Skinner.
You're on mute.
Under number 1, we specify appoint counsel.
Correct.
Why would we not specify appoint counsel in this case?
Yep, that was my question.
It was two. I think everybody should get counsel. I was trying to be fiscally. Okay, listen, this is in truth, these are requests from law enforcement. So if law enforcement is involved, that means their attorneys are involved. So maybe it's only fair that counsel are appointed in these cases as well. I would favor that. How do other people feel?
Me too. I would favor that.
I'm fine. Yes.
Yeah, that's great.
Okay, so require appointment of counsel, notice to everyone, meaning the public defender office. And so we're not dealing with dead lawyers and whatnot. But no
Because
presumption.
people also have counsel. I mean, there are some individuals who have retained counsel or who had retained counsel that wasn't a public defender, right?
Correct. Those counsel are long gone, right? Because they weren't retained. They were retained 10 years ago. That means that's why we should notify the public defender. As far as I know, my office is the only office that's offering pro bono counsel to these people. So, and we get notice of all of them and we are providing services. But I think that even in those cases, the public defender in the county should receive notice that this is happening and that they should be appointed counsel. And when an appointment of counsel is required, then the defendant, or in this case, the person who's incarcerated, has an opportunity to retain their own counsel, but it makes sure that nobody falls through the cracks without an attorney.
Very good. Okay.
Okay. Number three, this is would be the biggest change that we would recommend, and this is what I'll call colloquially the Cory Booker suggestion, which is that everyone in custody who has served 15 years incarceration may on their own petition for a second look. This would, their standard would be their continuing incarceration is no longer in the interest of justice. That is the current standard of 1170D. So the question is, do they meet their 1170D standard? So do we want to allow that at all? I will note that we've done some analysis on people who have served 15 years of incarceration or longer. I think it's 85%, I can get you the exact number, but north of 80% are already deemed low risk by CDCR. If we go to 20 years, it's 95% of people are deemed low risk. Now that does not necessarily mean that their continuing incarceration no longer in the interest of justice, but we're dealing with a very low risk population. You would not get appointed counsel automatically, because that would just retry everybody, and that would be, I think, too burdensome. We would allow judges to appoint counsel in appropriate cases. We would require notice to all sides with written decisions. And then again, courts can, no presumption. Courts can grant or deny for any reason rationally related to sentencing, and that's from the Dix case. How do people feel about this?
Question. The 15 years, some people, as we know, would have potentially served some amount of time in a jail first. And if you're longer sentence, maybe you were even there longer. So I want to just, make sure that we clarify that means in custody. 15
years of incarceration.
Right.
Yes.
So regardless of where, and that
Right.
isn't necessarily that you must then have it's not tied to what the term of your sentence is. It's the time you have been in custody.
Correct. One exception that we were thinking of is if there was more than 12 months left in your sentence. So for example, we didn't want people petitioning if they were only have a month left in their sentence. That was mostly a judicial resources situation because that takes time. On the other hand, I don't know if that was necessary restriction or not, but that was one consideration that we had. But absolutely, it is about time served. It's not about your sentence, and it's not where you served your sentence. If you've served 15 years in custody total, that would make you eligible. Several states have this. This is, I would consider a modern reform. And one of the reasons why I like it, and I'm curious about what judges think about it, is what happens in my experience, what happens in trial courts is people get sentenced and they're forgotten about. The prosecutors forget about them, the public defenders forget about them, the judges forget about them, and that has a lot to do with case load. Move on to the next one. This would allow judges to revisit old cases, remember that these people exist, and to come back to give incentives for people to say, all right, I just got a 40-year sentence, but if I work my ass off for the next 15 years, I might be able to convince Judge Espinoza that I deserve a reduction of that 40 years. And at the outset, it will also give Judge Espinoza or whomever, Judge Jones, an opportunity to say, I'm giving you a 40-year sentence. You have a chance in 15 years to prove to me I'm wrong. That's some of the rationale behind it. So I support this idea.
I don't have any concern about it. I think 15 years is a substantial sentence. And, as we know that, criminal predisposition or activity is really related to age. And I think someone who's been in prison for 15 years or in custody for 15 years has had a long time to think about the future, if there still is a future. And, I think it's the right amount of time. Because you're figuring the sentence that was imposed is going to be something like 25 to life or something to serve
Right.
15 years.
I should also note that if it is a life sentence, if it is 25 to life, let's say, the best under 1170D that a judge could do would just get you to the parole board earlier. They could not order you released,
Yeah.
right? Because it's a mandatory minimum of the life sentence. So for those situations, you'd get sentenced to 50 years to life, for example. That means you don't get to the parole board after serving 50 years. This would
Right.
allow you to come back after 15 years and say, Your Honors, please let me go to the parole board earlier.
Mhm.
Judge Espinoza, I'm curious your thoughts.
Yeah, I think 15 years is the right number, and I agree with Carlos. People age out of this behavior, and there are quite a few geriatric folks in state prison that don't need to be there, based on a public safety standard, right?
Right.
I will also note that I was pleasantly surprised that Judge Cousins, who was a representative from Judicial Council, I was concerned that Judicial Council would worry about court congestion and revisiting old cases and undermining finality, but he endorsed this, and I was very encouraged by that. Assemblymember Kamalager Dove,
Yes, I support this.
Senator Skinner or Dean Richardson?
I support it.
Okay, so with the exception of, for number 2, adding a right to counsel, this is not a constitutional right, it's a statutory right. Let's just make that clear. I'm going to move to accept this as our 10th recommendation. Congratulations. I think this is a great one and will be very helpful. So thank you. All right, with that said, I'm going to move back to our issues that we were revisiting. Tom? Yep.
There is a 4th number here. I don't know if we just want to
I'm
skip
sorry.
it, but just wanted to point it out.
So the number 4 there is, do we want to have financial incentives for courts and agencies to make these recommendations? I'm on the fence about it. I want to incentivize people to revisit these cases. On the other hand, we have a very clean, clear proposal, and this would complicate things.
Yeah.
I don't know, Senator Skinner, you're the budget whiz.
Say, repeat it for a second. So
Tom, will you explain?
my brain wraps.
Sure. Basically, I think the best framing is, if a prosecutor wants to bring one of these cases, they have to, investigate it, bring it to court, pay for all the upfront cost of bringing it, which, someone's been in prison a long time, lots of prison records, lot to organize and go through. And then if the person is resentenced, the state is saving a lot of money from the person getting out of prison. So the prosecutor pays to save the state money, which from an equity point of view is totally fine. But from an incentive point of view, perhaps prosecutors' offices would, if they could get a little chunk of change back from each one, would devote that to investigating more. And so it would sort of pay for itself from the front end point of view. And it could sort of,
Now
that's the big.
I understand better. It's the whole incentive thing. However, I think that in a way we're better to be silent on it, because there are many potential costs in all of these, whether public defenders, the courts,
Judges.
prosecutors, judges. And so obviously, if at the point that these things are adopted, there's going to have to be lots of budget discussions and lots of trying to figure out how how to best provide for it, whether through an incentive basis or through something else. So I think we're better to be silent just because we wouldn't necessarily be able to, in this conversation, anticipate what all of the different budgetary implications are.
The other thing is, if you were to do this
Go ahead.
and you offer the opportunity for defense to engage, then you don't have a situation where you're just relying on prosecution to bring these forward. So
Yeah, I'm wondering, do we have kind of just a general estimate of the number of incarcerated people who have served 15 years? I mean, is there going to be a floodgate of applications?
This is a significant number. Just to give you a guess, is that forget about the 15 years, but just number 1 and number 2. George Gascon has announced that they think that there are 20,000 people who fall into number 1 and number 2.
Yeah. Okay, well, that could be, although I think the courts would probably appoint, one judge to handle all this, 1 or 2, as they've done in other instances. I'm just wondering if it's going to be a huge increase in kind of like looking at these cases, giving them a second look, as you say. So that's just an unknown. I don't think we have to deal with that. But it is, I think the presiding judges and the Judicial Council may be concerned about the increase in workload for the judicial system.
So my sense is that we table number 4. We follow Senator Skinner's advice on that, and unless people disagree.
Yeah.
At the same time, perhaps it's not a formal recommendation of this committee because it's not really part of the penal code, but we are asking more of judges. We are asking, and I think that our general posture, I would suggest that the general posture of the committee is to support proposals to help make courts whole from the all the actors, public defenders, prosecutors,
Yeah.
from the proposals that we are proposing.
Well, maybe I hate to use the word make whole because I don't know if anyone's made whole in any of our budgetary processes, but I think certainly that to be conscious of we acknowledge that there are budgetary implications.
Yeah. And I don't want these judicial councils and others to say, hey, you're adding all this burden on us, but you aren't even acknowledging that it is a financial burden. And I think that we should, as a committee, acknowledge it is a financial burden, and that we don't want them to be put more in the hole as a result.
and they're going to say that anyway.
Yes, but let's at least acknowledge it, and let's not stand in there.
Yep.
I guess I want to support that, and that is not a formal committee. That's not within our purview of revision of the penal code. But I think it should be a sort of as chair, I want to take that posture, if that's. I want to try to be a good partner with these people. If they're acting in good faith about their budgets, then and we're adding extra work, then I want to act in good faith about supporting that, with also recognizing that we're having net significant financial savings to the state as a result of these proposals. All right. In the interest of time, I think that we've reached consensus on number 10 with the elimination of number 4. So I'd like to move back to our prior conversation from yesterday. Okay, without objection, I'm going to do that. Thank you again. I think that this is a big proposal. Okay, I'm going to slide 12, which is proposal 5. And what was left to be discussed, this is about presumptions in 1385 cases, and the question about what should be the standard for judges to overcome the presumption. The proposal that was on the table was if clear and convincing evidence shows the dismissal of the enhancement would endanger public safety. There was concern from judges Espinoza and Moreno about this standard. I don't know if you guys have had a chance to sleep on it and thought of alternatives, or you want to comment further.
Okay, yeah.
And if it would be helpful, Mike, we were able to find a few examples of presumptions in the penal code that would have to be overcome by clear and convincing evidence.
Okay.
But I can go through them, or you can take our word for it, or whatever would be
Take
helpful.
your word for it, yeah.
Yeah,
Which
I
is
guess.
to overcome presumption, except for judges overcome presumption. Yeah,
I mean, it certainly has more teeth with a higher burden.
yeah.
So I think I'm okay with that. Can you
You know,
give me a couple examples of penal code presumptions that have to be overcome by the higher standard?
Sure. There's a pretty big variety. I think the most relevant one follows up on a little bit of what Senator Skinner was saying yesterday. There was a bill from this year about peremptory challenges and sort of race or ethnicity based peremptory challenges. And there's a list of reasons where if a strike is justified by one of these reasons, like I don't like the person's neighborhood, it's presumptively invalid unless the prosecutor can show by clear and convincing evidence that it isn't. So that's a very recent one from AB 3070 this year. And then going back quite a bit further, Penal Code Section 26 says there's a presumption that someone who's under 14 is not capable of committing a crime. Parents may disagree, but that's what the Penal Code says right now, and that can only be overcome by clear proof, which has been interpreted as clear and convincing evidence. And there's more like that. I mean, it's perhaps things that aren't used every day, but there is a precedent in a few other places as well.
Yeah, my concern, not so much with this one. I think I'm okay with this. On the parole denial thing, the basis of my kind of concern was that, I think that the whole parole release thing, if it implicates the governor or even judges, is fraught with political overtones. And
if I may interrupt just there to keep us on track, Justice Moreno, can we just focus on this one? The parole denial is our next slide.
Well, I'm fine with this.
Okay, so
am I.
Okay, great. Resolved that number 5 is now adopted as our 5th recommendation. Thank you guys both. Thank everyone. Now I'm going to move to the parole issue that Justice Moreno just raised. That's slide number 22. Oh, shoot, hold on, excuse me. Okay, you'll see that this includes a couple of strikeouts based on our conversation, but number 9 is, and that we've reached consensus on all of them. We can go back over them if they're helpful to people, but where we have not reached consensus is how to increase judicial review of parole denials. The current standard is that a parole denial shall be upheld if there is some evidence, or another way of putting it, any evidence supporting that parole denial. That is the most deferential standard of review that I can think of in any court proceeding ever. One step up would be abuse of discretion, meaning they shall be upheld unless there's evidence of abuse of discretion. Abuse of discretion includes relying on absolutely incorrect facts, meaning, this guy had committed a rape 15 years ago, and actually that was just a misstatement. Right. The record does not include that. That would be abuse of discretion, or if they misapplied controlling law.
Yeah, right.
So those would be basically the 2 areas of abuse of discretion. Otherwise, the decision of the parole board, I just got a bad feeling about this, and I've looked at the entire record and I think that they remain an imminent risk to public safety.
Right.
That would be affirmed.
Well, I don't think it's that simple on some evidence, but I'm in, the basis of my concern as I was saying earlier, is that I think that, the governor and the court should accord a significant amount of deference to an agency that handles hundreds, if not thousands, of these decisions. And courts and the governors don't handle as many. The judge, the governor, very few, and the courts, not that many.
Well,
So,
the governor does review all of them, so they'll
Yeah.
say that they handle all of them, and
Yeah.
they do take them seriously and takes an incredible amount of their time, maybe, and it's in the Constitution.
yeah,
I think
And
the presumptions will help.
there was a previous governor who reversed almost every grant of parole
yeah,
Well, that was
during
did
my
not
time
require
as
a
the
lot.
supervising judge.
It did not require a lot of thought in those cases.
yeah,
But in the cases where they are granting, where they are signing off on them, I mean, I know the people who are involved in this in the current governor's office and in Governor Brown's office, and they took this extremely seriously, and the governors themselves spend a lot of time on these individual cases.
right, right.
But we're talking about, I do want to try to focus the concern on the
Yes.
judicial
Judicial
review.
review.
Yes,
Right.
Dean
yes,
Richardson has.
because if we
your-
could put restrictions on even the gubernatorial, I probably would recommend them, but I don't think that's
You're
not
gonna- right.
what we're.
Well,
Yeah.
to jump in there, the presumptions that we've talked about will apply to the governor, so it hopefully will help the governor's decisions making as well.
Oh,
Can I ask, Michael, will this presumption also apply to judges reviewing gubernatorial reversals of parole grants?
The standard would be the same because it's a denial either way, yes, but Dean Richardson, you had a question?
So yes, I would be in favor of an abuse of discretion standard. Some evidence is basically no review at all. The judges, I'm sure will disagree with me, but some evidence, it's really easy to find some evidence. And
Right.
discretion seems appropriate because if they have abused their discretion, then someone should be reviewing that, and there should be some consequence to that. And part of the reason I'm thinking this way too is all of the testimony that we heard about parole from the witnesses that came. So I would be in favor of at least an abuse of discretion.
yeah, that's my position. I mean, we have here a system that, in a normal situation, parole is granted. The presumptions, we have a number of them laid out. So kind of the deck is stacked already for granting parole. So if they, in an instance, and I know it's the figures we were given, it's like, what, 22%, they still do not, they only grant parole in 22% of the 22% of the cases under existing law. I think with these presumptions, that has to go up. That they're going to be granting more parole decisions, and if they deny one, I think they're going to have a substantial basis for doing that. So I think if a court gets involved, I think abuse of discretion is the appropriate standard. It's not clear and convincing. I think that's too high a burden for this kind of review of an agency's decision that has expertise in this area. So I'm happy with abuse of discretion.
All right. I think abuse of discretion is also quite deferential, but I think and we should also know that some evidence is a pure court-made rule. There's no statute that says this. That was just the
Is that
court
from Lawrence, or where is that from?
Yeah, Lawrence, Chaputis, and those line of cases.
Yeah.
It traces back to a 1985 United States Supreme Court decision about the revocation of good time credits, and it was sort of adopted by the California Supreme Court around the same time.
Well, it's a pretty lenient deference standard then, yeah.
Does anybody have any problems with abuse of discretion as the standard?
And this is related to just review of parole denials.
Correct.
Okay, yeah. Because I didn't want to necessarily be in a situation where we were recommending an increase of review of all parole board decisions, only because we're already, if we think about everything else we've just adopted, we're already putting a lot more onto the court. So, but in terms of the denials, again, we'd want to make sure that we are clarifying why we would want a second look. And I think that the abuse of discretion is that's a good standard.
And just to also just make sure people understand, there's a fairly well-regulated process in the courts under habeas corpus about how and when counsel is appointed, when orders to show cause should issue under this. We would not be altering that. So that process would remain in place, and we're not messing with that. So there's consensus on Assemblymember Kamal-Gaddafi, you haven't weighed in. Okay, thumbs up, good. Consensus on abuse of discretion.
I'm fine with that.
Great, thank you. Because we're doing very good on time, thank you all. I'm going to add a wrinkle of my own because it's something that is unclear to me as to what is the remedy that a judge, and perhaps staff can jump in if I'm mistaken, that the remedy is not clear for the Superior Court. There seems to be one of two remedies that if a court finds abuse of discretion, they can send them back for a new parole hearing, or they can order their release. Do we want to clarify that neither of those remedies are available, or
If I
require
can,
one or the other?
if I can jump in, Mike, I think the second one may be possible in some very extreme cases, but I think the most common and appropriate remedy is to just send it back for another hearing. And
Yeah.
as you know, by the time you've gone to court and got a resolution, you may be scheduled for a new hearing anyway. So it's
Right, which
you
is
know,
why I'm suggesting that perhaps a remedy should be release.
I think that would
Yeah, I
take
think
a
you leave it up
statute.
to I think you leave it up to the court to decide whatever. I mean, if
Well,
there's a
right, do
statute-
we say in the statute that a remedy, that they have, if it's found, upon a finding of abuse of discretion, the remedies are remand for a new parole hearing at the earliest possible date, which of course, in many, if not most cases, is already scheduled. Release, or whatever relief seems appropriate to the judge, and we make that explicit.
Though note that if it's remand back to parole board, that it can be 2 years.
Yeah,
Correct.
you
That's
can
why,
release him from custody, but he's still on parole, let's say, I mean,
correct.
and awaiting that hearing, and that, if your concern is about remaining in custody.
I mean, there are some rare cases also where people get out, but they haven't gone to the parole board yet. They're sort of like
Right.
out on their own recognizance. Then they have to
Right.
walk back into the prison to have their parole hearing, in
Right,
which case they can be found unsuitable for parole. So it's
yeah,
sort of great. I know it's a very scary prospect.
Yeah, the other thing that we should be mindful of is that if the Superior Court orders someone released on parole, the AG is likely, in many cases, to go to the Court of Appeal and ask for a stay of that order.
yeah.
That's within their prerogative.
Yeah, I'm just saying it doesn't automatically mean that somebody's going to
No.
walk out.
Mhm.
Perhaps one of us, perhaps Dean Richardson will be our new Attorney General, and that problem will be solved.
I'm
No,
ready for that, yes.
I nominate her. I don't know if we can make that a formal recommendation or not, but
no, I reject that.
I'll have to write a memo first, unfortunately. So
But to go back to your original question, I don't see a problem with making it explicit, the alternatives that you gave.
I agree.
And to be clear, are those the only alternatives, or are
no,
there?
I would leave a catch-all, or which is common, which is basically, or any other remedy that the court finds appropriate. That's not,
Okay.
that's,
Okay.
part of a statutory idea here could include addressing the stay issue, Judge Espinoza. I know in the when it comes to prison release orders in federal court, there are sometimes, that's part of the relief in the statute, in the Prison Litigation Reform Act. There are automatic stays, or the standards are different. Maybe not appropriate for us, but wouldn't be out of the ordinary for something like this.
I would oppose, let the AG apply for a stay, then the courts can reject or approve that stay. Let's not get mess. If there's legitimate reasons to stay, there should be legitimate reasons to stay. I think there's checks and balances on that. I think I would recommend to leave it as, give the courts the authority to release somebody, make that clear, and any other remedy. And if the Attorney General feels like that needs to be stayed, then there's a battle about whether or not the stay is appropriate, the balance of interests, and there's a whole.
Yeah, my reason,
And it could be appealed regardless of the stay. They
right.
can say it's granted, but it's appealed, and then it possibly reversed.
My only reason for raising the Attorney General's participation was to highlight the fact that there is a check on judicial decision-making.
All right. So to try to wrap this up, number one, judicial review will be reviewed for abuse of discretion. Number two, if the court finds abuse of discretion, the remedies are A, remand for a new parole hearing at the earliest possible date. B, grant parole, basically sort of a mandamus to grant parole, release the person on parole, or 3, any other remedy that the court finds appropriate.
I am supportive of that, and then that it is that standard of abuse of discretion, though I don't want it to be interpreted as a hierarchy. So in other words, I don't want it that first and foremost, they would remand it back to parole, because if they feel, I mean, I'm projecting a little here, but I think it won't be a large percent of cases where a judge wants to overturn the parole board. So in those situations where they do, and of course they have to give the reasons because they felt that there was abuse of discretion, then I don't want it to be viewed by the judge that we are saying, well, then our first recommendation is bring them back to parole board. I think we want it to be equal. I mean, they should just know they have the authority under what we're recommending to allow release.
I agree. And I think that we can make that clear. All right. With those amendments to number 9, plus the amendments from yesterday, does anybody have concerns? Or I would move to adopt this as our 9th recommendation.
I agree.
Excellent. That makes us, that concludes our recommendations. That's 10 recommendations, which in the course of this year, COVID, Black Lives Matter, so many different, the presidential election. I think this is an incredible accomplishment. I'm very proud of these. We have touched on everything from traffic infractions for failing to drive without a license to life sentences and everybody who served more than 15 years and almost everybody in between. Obviously, these are not enacted into law, but I think that we really spanned, it was ambitious for us to look at that wide a range of punishments. We obviously have not, as I started off today, said, created a whole new rock solid boat, but I think we have patched a lot of the problems and inconsistencies that we heard about over the course of the year. And for the most part, I think that there was general if not unanimity, but consensus even amongst law enforcement and victims that most of these things that we're proposing make a lot of sense, not to mention the administration's issues. So I'm very proud of this work, and these will be our recommendations. They will be supported in the report with background material, data that we will now collect and be able to present, analysis, comparisons to other states. And that will be for the report that we will vote upon at our meeting in January. I think that we agreed that January 13th is the date. We will distribute a draft of that report early so that everybody has a chance to look at it and hopefully make comments and recommendations. I know that that's going to be a fairly lengthy document. The good news is we will have seen in various forms of another 90+% of it already in the memos that Tom and others have written and in these recommendations already. So there shouldn't be too many surprises, but please do. And I know it's the holiday season. You'll get it just after the new year or as close to that as possible, but please take a look at it, because this will be, I mean, the recommendations are formal recommendations. They've been decided, but the report will really be the full cake. Tom, do you have anything you want to add to that part?
No, I don't think so. We'll try, as you said, we'll try to get it out as far advanced as possible.
All right. Thank you all. We've had a lot of hearings, a lot of long hearings. We've heard, Tom, how many witnesses do we have? Did you know, do you have the list?
I think it's in the low 50s.
Okay.
That was the last time I checked.
I think I may have said 70, so I exaggerated. But we've had Governor Brown, Governor Newsom, the Attorney General, Felton Henderson. We've had, the Crime Victims United. We had a person who is currently incarcerated in prison come and testify. So we, activists, community members, attorneys, lawmakers, members of the administration. So thank you, staff, really, for pulling that all together. All right. Unless there are any other administrative matters or other matters, Tom and or Brian, can you weigh in before we move to public comment?
I don't have anything.
Me neither.
All right. So it looks like we have another large crowd of 70 or so people in the audience for public comment. I don't have my cheat sheet here about what I'm supposed to say, Tom, but what I'm going to ask now is that people begin lining up in the queue for public comment. I think use the raise your hand function. If you're calling in, I think you dial *9 or #9.
It's one or the other. Let me double check, because I think one works and one doesn't. So
*9, I believe.
*9. We'll take these in order. I'll give everybody a few minutes to get set. And in the interest of taking a break, why don't we the committee members, we'll take a 10-minute break as people line up, and then we'll have public comment. Does that sound good? All right, thank you. I have that it's 10:30. We'll reconvene at 10:40. Okay, it's 9:40. If people could come back to their desks, let's get this public comment started. I know that some of the members have hard stops at 11, so I want to be started, and thank you everybody for your time. For those people with public comment, I'm sincere that I appreciate, or we all appreciate, the public comment. I want you to know that the public comment at the meetings is obviously quite brief. I like to try to briefly explain our reaction to things that you might say, but please keep your comments to 90 seconds. And if you have longer comments, we get many emails, and it's much more, you can get a much more substantive comment and response that way. And our email is available on the website. So if you have a longer comment or substance to say, I would encourage you to do that, to submit your comment that way. All right, I'm just setting my timer.
And Mike, just to jump in, we do try to reply to as many emails as possible, but sometimes we just can't. So I want to set that expectation as well.
Yes, of course. And we are, listen, this is our first year. We're trying to set up an administrative system that we can respond, at least in part, to everyone. And people should know that we do not have a giant staff, and our administrative staff is actually a half-time person. So please be patient with our responses, but emails and letters are generally the best place for substantive or longer comments. We do take them very seriously, I promise you. All right, that said, and in the interest of time, Joseph, I believe that you're first in line.
Hello? Hello?
Yes, Joseph, can you speak up a little bit?
Yes, indeed. Big thanks and congratulations on this. A few years ago, to say nothing of 50 years ago when I was a federal prisoner for a few years, this was far beyond imagination and hope. A couple of things that underlie the problems you're trying to deal with, and I think I just want to name them now. One of them is that crime and harms are not exactly the same things. And those of you who are legislators, and the rest of you too, know that the bidding war in the 80s and 90s that raised sentences and enhancements and all the things you're trying to thread your way through now. So that's got to be dealt with. Another one is that you haven't arrived at, and it's hard to do, a theory of sentencing and a theory of custody. When is a society obliged to restrict somebody's human rights by holding them in custody? I'm not saying yes, it's a lot of occasions or not a lot of occasions, but there should be really some clear standards. And I think that'll help you with parole, with sentencing, with pretrial, with this whole process. The third thing is somewhere along the line, the justice system has to deal with the social context that the people come from. You've tried to confront that and deal with it, even in one of these last points, talking about people's background or childhood abuse. But that's another critical part there. If the justice system doesn't confront that and the racial feelings and inequalities in society, then it runs the risk of compounding those inequalities and generating more of all kinds of crimes, the harms that are called crimes and the harms that aren't called crimes. And I look forward to your continued work, and I hope to support you in those points and others. Thank you so much.
Thank you, Joseph. And I will just say, I agree with you that there's a lot of competing interests in punishment, from retribution to public safety. And I think that we're trying to help move towards one that concentrates on data and public safety, and not in a way that perhaps where ideas of retribution, which may not even be that sound in the first place, have maybe overtaken our system. But I also take your idea of a bidding war, I think, is very well taken. Eva.
Hello. So yesterday, the committee approved the seventh proposition thing. to retroactively apply the repeal of 2 recent sentence enhancements, the 1 year for prior felonies and 3 year for drug convictions.
Yes.
Yeah, I agree that this is an important step and should be immediately enacted. And I want to acknowledge that the repeal of these enhancements was thanks to a broad-based organizing effort by impacted communities. And I wanted to stress the importance of not limiting this retroactive application to just these 2 sentence enhancements. And in particular, we hope the committee will explore the retroactive application of all recent changes to sentence enhancements, regardless of whether the reform was a total repeal or a change in judicial discretion.
Yes, thank you very much. We chose the ones that were automatic for the reasons that I think in a general purpose, we believe that if it's change going forward is the right thing to do, then it should be the change going backward as well. The ones that were discretionary, some were protected by initiative, so we couldn't eliminate those automatically, and we really wanted to get the ones that we could get done. And you're right, they were driven by a lot of grassroots organizing, and Senator Wiener, I believe, was the author of the legislation, so that was a big effort, and it affects tens of thousands of people. So thank you very much, Eva. Next in line is a phone number 146. If your phone number is ends with 4617. Hello, we can't hear you if you're talking.
Hello, my name is Joe Bear, and I'm calling from the Transgender. Hi. Yeah, I'm calling from the Transgender, Gender Variant, and Intersex Justice Project, or TGIJP. Our members, and especially our Black trans members, have been particular targets of the criminal legal system, which is why we believe the penal code needs dramatic revision to end criminalization and incarceration. We call for the appointment of formerly incarcerated people to this committee for 2021. The absence of impacted people on the decision-making team is a huge mistake and a loss of the vital expertise necessary to make the changes you need to. Additionally, the committee is considering recommending a presumption of parole denial if someone is either evaluated by a psychologist to represent a high risk for future violence or has rules violations reports in the last 3 years. This rule would directly target TGIJP's members who regularly face retaliatory actions by prison staff and often lack culturally competent mental health care in prison. We completely oppose that recommendation. With regard to the other measures that the committee considers, TGIJP and its members call for the abolition of systems of imprisonment and policing that target our members. We support any measures that will move us closer to this goal. Thank you.
Thank you very much. 2 quick responses. I know the governor thought hard and long about who would be appointed on this committee, and we wanted to try to avoid one person from this side, another person from that side, and try to focus on academics and judges. That's the bulk of the folks on the committee. And with regard to the recommendations of the parole denial, that was stricken. We are not making that recommendation. So I hope that concern is resolved. Mr. Ramos.
Hi.
Hi.
So my name is Jonathan Ramos, and this is actually an issue that is very near and dear to my heart, these sorts of reforms and this sort of work. At the age of 21, I was arrested and after that subsequently convicted of attempted murder and sentenced to 12 years to life in prison. I spent the last 9 years in prison. The fact that I am here today able to talk to all of you is a direct result of the type of work that I see right here in front of me. And it is, I'm almost speechless. It's humbling, it is inspiring. It gives me a lot of hope to continue with the rest of my life. And it's just interesting to see things from the other side of the discussion. And I currently work now as an intern with an organization called Self-Awareness and Recovery. We're located here in Sacramento. We work with underserved and at-risk youth and people who are currently incarcerated and who have been incarcerated. So these sorts of issues relate to my situation in particular because of the need to understand that people end up in prison for a variety of different reasons. In my situation, those reasons revolved around mental health. Mr. Romano, I'm not sure if you remember, but in 2014, Mayor Daryl, or at the time, Senate Pro Tem, Daryl Steinberg had spoken in advocating for the Mental Health Services Act, and he used my case and my situation as an example of the need to take a look at these sorts of things. So again, at the time, it was very humbling and very inspiring, and that's what inspired me to continue to progress through my time in prison, to do the things that I knew that I needed to do in order to secure my release.
Thank you. Mr. Ramos, I just want to cut you off just quickly to say that your time is out, but number one, keep on telling your stories, the stories of people who are being able to get out of prison, especially who are sentenced to very long sentences and to succeed. It really does change the world. I do remember your story from Mayor Steinberg. Mayor Steinberg has been a champion, true champion of people in the system with mental health issues. Good luck to you, and keep on telling your story. It really does make a difference to us.
Absolutely.
And in general. Thank you. Good
Absolutely.
luck.
Thank you.
Ms. Shear. Joanne Shear.
I'm sorry, I didn't unmute. My name is Joanne Shear, and I'm with the Felony Murder Elimination Project. I would like to thank this committee for all of the work that you've done over the year, and I'm so admire everything in your conscious decisions to try and change what we've put in play for so many years back. Brandon Bernard was 40 years old when the government employee killed him yesterday. He was 18 years old at the time of this crime. Yesterday, he was 40 years old when we waited for him to die in the name of justice. California houses over 10% of the US population sentenced to death in prison. We have nearly 6,000 people serving a death sentence, whether by execution or incarceration, caged in cells waiting for death in the name of justice. Penal Code 190.2 Special Circumstances is a list of 37 circumstances which mandates death in our state. The harshest sentence known to man should demand a greater burden of proof of guilt beyond reasonable doubt, but it doesn't. The 13 felony murder special circumstances are the easiest convictions to win, since a prosecutor is relieved of the burden of proving intent to kill. They need only prove intent to commit the underlying felony. The prosecutor alone makes the decision to charge a special circumstance. There is no type or level of crime that demands the charging of a special circumstance. Judge
Shear, if you could wrap it up real quick, because I do have a couple of things I want to say.
California legislature has the ability to roll back life without parole sentencing by repealing Penal Code 190.2 subsections B, C, and D with a 2/3 vote. We implore you to address this in the beginning of next year. Thank you so much.
Thank you, Ms. Shear. Congratulations, first of all, on your work on the felony murder rule. That was an important reform from last year. The death penalty in special circumstances is certainly on our, and Senator Skinner is obviously important into that. Death penalty in special circumstances in LWOP is definitely on our radar for next year. As you probably also know, the California Supreme Court is reviewing the constitutionality of California's death sentence, and the current governor, Gavin Newsom, recently filed a brief stating his strong position that the California death penalty is unconstitutional. And furthermore, as you know, that we set out as a ground rule for ourselves that we were not going to address issues that required a 2/3 vote purely for practical reasons to try to limit the scope of our work for this year. But does not mean that we don't agree with you and that we will look ahead to the future to some of these issues. If your phone, next in line is his phone number, whose last digits are 7256.
Okay. That's what I wanted to say. There you go. All right.
Thank you, Joanne.
Hello? Hello? Can you hear me? Okay, wait,
There's an echo.
Yeah, hold on, just a second. Okay. Hi, Crispy, Stop San Quentin Outbreak Surge, Initiate Justice. Thank you so very much for all of your hard work, and I appreciate the efforts of this committee. You inspire me to fight. So here's some tough love. I'd watch you search for solutions to problems that you do not completely understand, because only those closest to the problem can solve the problem. It feels like going to a BLM meeting where no Black people were invited to be to the table to make decisions. Why are there no system impacted people with lived experience on this committee? Example, Shay Franco Clausen, a formerly incarcerated gay Black woman who was elected to work on the board of the Santa Clara Valley Open Space Authority. She checks a lot of boxes. Reality check, 96 people are dead. With COVID-19, we saw the failure in leadership with the federal receiver, CDCR, CCPOA, our court system through Von Stage, and the San Quentin habeas case, which right now are forcing the involuntary transfer of well people and the sickest people out of San Quentin to die at Corcoran with zero medical compliance instead of releasing them. I beg you to bring system impacted people to the decision-making table and be bold like DA Gascon and change the penal code to release people now. Thank you very much.
Thank you. As you know, and as I said before, we have no part of who was nominated to put on this committee. At the same time, we have made extra effort in every single one of our committee hearings that system impacted people played major roles. I encourage you to talk to to lodge your request to the governor if you feel like this committee isn't appropriately represented. But we really are doing our best to have as many different voices from all sides of the spectrum heard, from victims to people who are actually currently incarcerated. And I bet, I venture that that was an unprecedented effort, not just people who are system impacted, but somebody currently incarcerated. And to that extent, I'm proud of our efforts to reach out. But of course, I understand your other points. Ms. Naravette.
Hi, thank you. My name is Yolanda Navarrete, and I am a retired employee through UC Davis Medical Group. And I am also an advocate with Initiate Justice in the Drop LWOP Coalition. I know you don't want to talk about LWOP and you want to wait, but we are in a pandemic, and the governor can, and the head of CDCR can use government code 8658. I'm not going to waste any time reading it. I'm sure you guys know what it is, but we don't need to wait. We're in a pandemic and people are dying. So if you could please address that, we would greatly appreciate it. And thank you so much for all the changes. You give me hope. My husband has served 26.5 years, costing the state over $2.2 million. I'm not doing it just for him. I'm doing it for my 11 grandchildren that can get caught up in the system so easily. So thank you from the bottom of my heart. You give me hope.
Thank you. I will just say all of us are very well aware of the COVID situation in prison. This is just one part of our job. This particular committee is not tasked with addressing that problem. We hope that our reforms will help alleviate the situation moving forward. But I can tell you that in my other jobs, I am working on this issue day and night, as I know are many other members of the committee. So this is not the only venue that we address these problems. Believe me, we are fully aware of the emergency that's going on in the prison system right now. Thanks. Mr. Gonzalez.
Hello, good morning. I want to thank the committee for all the work they've been doing today. And I'm ex-incarcerated as well. I've been out 7 months. I had 2 life sentences. Thanks to
congratulations
for the felony murder rule. I appreciate her work. But in the meantime, I want to address the enhancements. There's a lot of people in prison that have trauma that's never been addressed and is not taken into consideration when the sentences are being enacted. And that should be a primary thing to address all the factors that lead up to why the crime was committed in the first place. You know, many people have trauma that has never been addressed, and it needs to be addressed. It's an important aspect of why people end up in prison. Unresolved trauma. I just want to thank you guys and hope for the best.
Thank you for your comments, Mr. Gonzalez. Please keep on telling your story. Good luck to your success. It's really remarkable that you're out. I will also say that one of the recommendations that we have is to give a presumption of striking enhancements when people are victims of trauma. So we're doing our best to address that specific problem as best we can with the constraints of the law. So thank you. If your telephone number ends in 1770, you're next.
Good morning, members of the committee. My name is Daisy Chavez, and I am the statewide advocacy manager for Initiate Justice. I just wanted to start by thanking the committee for including the recommendations made by our executive director to apply credits towards youth offender parole hearing dates. We firmly believe that this is something that's really going to help many of our members and others who are awaiting CDCR, the responsibility that they have to implement AB 965, which passed last year and instructs them to apply credits at their discretion to youth offender parole hearing dates. I also just wanted to comment on inclusion. Our organization strongly believes that we must include impacted people in conversations like these, where decisions are being made that could affect their loved ones or people who are in situations like the one that they were once in. In particular, the lived experience that formerly incarcerated people bring is invaluable. We believe that their voices could provide a great deal of input and even lead to bolder recommendations in the upcoming years. This committee is tasked with the responsibility of presenting recommendations that could change the penal code. It impacts thousands of people who are incarcerated, and that cannot be fairly done without ensuring that there are formerly incarcerated individuals in the conversation. So I ask that they be appointed to the committee in 2021, and thank you for your time.
Thank you, Ms. Chavez. And also I should extend the thanks to Initiate Justice in general. You guys have been change makers in a relatively short period of time. And so thank you for your comment, and your point is well taken about the diversity and well-making, the makeup of this panel. I'm going to mispronounce your name, Miss Segovia.
You said it right. Thank you.
Oh, good. Wow.
Good job. Good job. So first of all, I would like to thank all of you for your work here. It's really amazing, and it gives a lot of us hope. A major problem that I see, though, is static risk assessments for juvenile offenders. They're heavily flawed due to their age, and many will be excluded from a lot of these recommendations. In my husband's case, for instance, he was 16 and has served 9 years, but technically hasn't aged out of crime yet because he's only 25. I believe he's aged out. He believes he's aged out, and any kid who serves 9 years is going to be tired of prison and never want to go back. But these assessments don't reflect this. So I would hope that some data could be gathered on this and possibly considered as an exclusion in some of these recommendations. My husband should be out in November, thankfully, but many others may continue to be excluded due to unfair assessments.
Well, thank you. I appreciate that. And I know that the California static risk assessment gives a lot of weight to age because it's the most salient factor in terms of recidivism that hurts people who are younger. At the same time, it is not the exclusive ways that somebody can be evaluated as low risk, which is something that the committee acknowledged. We are also in close contact with the team who is responsible for the California static risk assessment of staff, and that we will be working with them. And a major, I said this at every meeting, priority of the committee is to collect the data to really make sure that these decisions are made as accurate as possible and not based on prejudices and assumptions. So thank you. Next up is Mary.
Yes, hi. Good morning. Thank you so much for this opportunity, and thank you so much for all the changes that you guys are bringing with this revision. I just wanted to bring out a couple of points on the agenda number 2, as far as serving time in jail. I think under number 4, it is not. I think it's not stated that there's a possibility for other alternatives after maybe serving 6 months. I know in our county, for instance, in LA County, Measure J is going to bring a lot of changes, and there's going to be a lot more alternatives to imprisonment. And I think that could probably be brought up. Also, under number 4, I would like to say and agree with Senator Skinner that the word aggravated really needs to be removed. That is a word that just, immediately is an eye opener. Under number 9 on the agenda, I think you guys referred to the CRA, and I think you just brought that point up, which I thank you for doing that. That CRA is very, very subjective and oftentimes more than we want it to be, very inaccurate. And I think that is something that definitely needs to be looked at. Under number 7, the BPH recommendations to house incarcerated population when programs are not available in their housing unit. I think that might become a big issue because unfortunately, with all due respect, CDCR is not in the best interest, to looking out for our incarcerated population. And there is a lot of barriers to housing that the BPH is not aware of and does not understand, such as non-designated program facilities and SNY yards, which could ultimately cause problems when that decision is made by CDCR themselves. So I think other alternatives, go ahead.
Go ahead, just finish your sentence.
I think other alternatives that can be considered would be just that those classes that are not offered, could be, there could be alternative classes that could be accepted as a replacement.
I actually think that that's an excellent idea, and the list that we've suggested is not by no means exhaustive, and we will look into that for the report. I think your point about Measure J is also especially well taken, and we'll make sure that the report accounts for Measure J with regard to any potential interaction with our recommendations. And finally, your point about aggravated theft and Senator Skinner's point was also well taken, and we voted to remove that word aggravated theft to avoid the concerns that you raised. So
great, thank you so much. There's
you're welcome.
one more point.
I'm sorry, we really have to keep this moving. If you do have further points, I really encourage you to email you. I hate to cut you off, but I'm just trying to keep this rolling so everybody gets a chance to talk. And so that, and I do really want to. Okay, thank you, Mary. Really, thank you. Very thoughtful comments. Jane Currant.
Sorry, I want to just add my voice to all of those who have appreciated your work and encourage you to really get moving in 2021 on dealing with LWOP. We have too many people languishing in our prisons. They may as well be death sentences. I appreciate your work on enhancements, but I'd like to suggest that you actually change the title of that particular recommendation to focus sentence enhancements on the most significant crimes. By repeating the word dangerous, you are simply buying into the narrative that we are all fighting, that just because there was a violent offense, that does not mean that the person who has served perhaps more than 15 years, usually more, is not entitled to be seen as the person they are today. I do appreciate the work on the parole hearings. I encourage you when you get down to it. I'm sorry, I'm going to wrap up here.
Yep.
Just thank you, and follow the lead of Judge Henderson, follow the lead of DA Gascon. Be bold, don't be afraid, and listen more to the folks who are impacted and get them on your committee. Thank you.
Thank you very much. We were all impressed with Judge Henderson, and DA Gascon. I may have been his first public appearance after his election was to speak before our committee, and I think we were also impressed and moved by him. I will say I appreciate your comment about the words dangerous and violent and significant. We intentionally did not use violent because of the exact concern that you raised. So words matter. And I hear what you're saying. Your point is well taken. Marion, you're next.
Good morning. My name is Marion Rickard. My husband has been incarcerated for 19 years without any disciplinary actions. Tommy is sentenced to 57 years determinate sentence, 22 years for voluntary manslaughter. This means that 35 years of his sentence are enhancements. 10 years of his sentence is a gang enhancements. However, there was no gang involvement whatsoever, none. Enhancements need to be removed. As for the 1170 recommendations and appointed counsels, judges have limited time. Attorneys can write motions explaining why someone should be resentenced and released to help with the limited time schedules. Superior Court judges need to follow through with resentencing, not blanket denials, which is currently happening. The county courts do need financial incentives from the state to help with the 1170s. I'd like to thank you all for addressing the elderly parole. That is very important. And I'd like to thank you all for seeing the humanity in people, as no man is rich enough to buy back their past, yet every man is entitled to their future. Your committee is of great importance. Thank you very much.
Thank you. We're honestly trying and giving our best efforts. Just a couple of quick specific responses. As you know, and we've discussed in earlier meetings, many of the enhancements, including gang enhancements, can only be reformed by 2/3 vote or initiative. We recognize that the gang enhancements in particular are very problematic. I will also say under the 1170D recommendations, we are recommending counsel for those cases. And finally, if our recommendations are made into law, your husband would be eligible to seek resentencing after 15, because he's already served 15 years under the second look provision that we voted on today. So good luck to you and your husband. Mrs. Espita, I'm sure I'm mispronouncing your name.
Espitia.
Espitia, apologies.
I just wanted to say thank you guys. Thank you guys for everything you guys are doing. My husband being served 26 years, charged as an adult at 15 years old, was just granted parole December 2nd.
Congratulations.
And I love the things that you guys are doing, the conversations you guys are having. And it obviously is not going to help him because he's got their own, fighting there, but it's going to help very many others. And I just wish that these processes after being granted parole for lifers would just be cut down. 120 days after 26 years of waiting to be paroled is just kind of ridiculous to me. And the fact that we have to wait for the governor to double check the people he appointed to make these decisions is kind of unnecessary, I feel. But again, I just want to thank you guys, and I look forward to seeing these changes.
Thank you for your comments. I think we all share some frustration about the governor's second look over the parole board's shoulder. It also creates political problems that I don't think that are helpful. California is only one of a very few states that include this. Unfortunately, it's in the California Constitution and not very easy to change. I hope some of the presumptions that we've suggested to be enacted will help that process move along faster. And congratulations to your husband. I know 150 days or 120 days is a long way to wait. But if there's one thing that the people that I know who've been in prison for long periods of time, they are experts in, is in patience and frustration. And he will be home in February, if my math is correct, or March. And I wish you all the best.
Mike, if I.
Yes, of course.
So I wanted to thank Mrs. Espitia for calling us and wish her husband well. And I just wanted to clarify that when we refer to our agreement on that we don't love this gubernatorial process, we are referring to a gubernatorial process versus any particular governor.
That's correct. It's the constitutional process of looking over the parole board shoulders. And I don't want to speak for the governor at all, but I think that they take this as a very serious responsibility, but also one that once they're given the constitutional responsibility, then they have to exercise it. And but perhaps is something that they would wish that they didn't have on their table. Again, I can't speak for any governor, but certainly most governors do not have that responsibility, and it's a weighty one that adds a level of politics to this process that I think is problematic. So
Agree, thank you.
Thank you very much, and congratulations again. Jennifer?
Can you hear me?
Yes.
Hi, I'm calling in to express support for the immediate and automatic retroactivity of SB 136. My family member was resentenced under SB 1437 in 2019. He went from being sentenced to die in prison with a sentence of 51 years to life to being resentenced to his actual crime and was sentenced to 3 years. But because he is brown, he was also hit with the 10-year gang enhancement and the 1-year prior enhancement. So he was sentenced to a total of 14 years, 11 being enhancements. SB 136 being retroactive would remove 1 more year from his sentence and bring him that much closer to serving the time that he was given for his actual crime, which he's already served more than twice that amount in a level 4 prison. So that's what I wanted to express. Thank you.
Well, as we've said, thank you. As we've said, we believe what's fair going forward, it should be fair going backwards. So that's our feelings about SB 136. If your husband was convicted out of Los Angeles County, now with DA Gascon, he may have a chance to resentence. And I know it's very hard on level 4 yards, but to do the best of the programs as much as possible to, when they get their chance, to get it, to prove to everybody that they have a chance to safely re-enter the community. But good luck to you. Thank you. I'm going to also mispronounce this name, but Siobhan?
Yes, can you hear me?
Yes, I pronounced your name correctly?
Yes, you did. Thank you.
Oh, good. Thank you.
So I just wanted to speak about the part about increasing judicial review on parole denials.
Yeah.
My husband he's a nonviolent third striker. He got to go to before the parole board March 5th, and he was granted parole. Unfortunately, once it went to the governor review, they brought up issues and said that he didn't start his change until he was 40. He's 46 now. That should never have been brought up. So it got sent to rescission hearing. November 17th, they rescinded his parole grant. And, I think that it's a lot of issues with BPH that need to be looked at. And I think that rescission hearings also need to go through a judicial review. It's crazy the way that things, he got granted and it just got yanked from under him. And I just think there needs to be a better review. And the discretion that BPH has sometimes is just, but I think that needs to be looked at a little bit more as far as rescission hearings. Because now my husband, he's under a mark of, a third striker that got granted parole, and they got that tick, but then they turned around and took it back from him. Thank you.
That is, I can't imagine the frustration. I hope that the presumptions that we are encouraging today will prevent the future, and that your husband, when he comes back before the board, has a better chance. I'm very interested in this case. I think my experience with 3 strikes. If you please write to the committee about a little bit more detail, I would be very interested in hearing more about it.
Yeah, I actually did send something to you. I don't know, and also to Senator Skinner.
Send it to the committee staff. That's the best way to get to us, I think.
Okay, thank you so much.
You're welcome. Mr. Palmer? Mr. Palmer? Mr. Palmer, we can't hear you. All right, Mr. Palmer.
Can you hear me now?
Yes, we can hear you.
I'm so sorry.
No, it's all right.
Okay. My name is William Palmer. Thank you for the opportunity to address you today. I sent a letter to the committee about Penal Code 290, which kept me in prison for 31 years and 22 days. I was incarcerated from the age of 17 to 48. My crime was for a botched robbery on an off-duty police officer with an unloaded weapon. YA decided to encourage the court to send me to YA, even trial as an adult, because they had the remedy to help me and let me out at 25. The court did not want to hear it and told me that either accept a plea bargain for 7 to life plus 2 or go to trial and we will prosecute you to have you with life without. This is a decision of a 17-year-old had to make without an attorney or a present and a public defender who told me to go ahead and take the deal. California is unique in requiring a life sentence for the crime for juveniles. I sent the commission a 50-state survey written by Professor Christian Bell of this subject. It is unjust and this law should be changed. I do not want anyone to go through what I went through. Please change this law. I fought with O'Milvany and O'Myers, making Hampshire as an attorney, that Henry Palmer now is rules and regulation for youth offender hearings. Henry Palmer now has given youth offenders a chance at a meaningful release, where SB 260 was just full of gums and a bunch of talk, smoke, and mirrors. We
Mr.
need
Palmer,
to control.
I'm sorry to cut you off. Let me tell you a couple things. First of all, with regard to juvenile LWOP, we appreciate that this is a very troubling situation. It's also protected by initiative, which is one of the things. I will also say about Kristen Bell, she's my former student. I'm very proud of her and we are in close contact. I'm very familiar with her work on this. Oh, excuse me, excuse my dog there. So I'm very familiar with this and believe me, it's on our radar. Okay. And then final, good luck to you and happy holidays. Good. Finally on our list is Fritzy. Now it's lost from my. Can you please introduce yourself?
Yes, it's Fritzy Horstman.
Hi.
Hi, I'm from the Compassion Prison Project. I just really wanted to, as you guys are going through this penal code, the RVRs that are handed out indiscriminately in prisons really need to be gone through with a fine-tooth comb. What happens in those prisons? Men are demoralized. They're demoralized just being in prison. That should be the sentence. It shouldn't be to continue to take away their programming, to penalize them for drug abuse. If they're drug abused, they've had childhood trauma. We need to bring childhood trauma awareness and education to all the men, women, living and working in prison. I have an initiative, Adopt a Prison. We will bring trauma-informed care and trauma-responsive care to all the men and women living and working in prison. But it's really important, these RVRs need to be really sifted through, because a man who created an interracial basketball game got an RVR. A man who wanted to walk across the patio got an RVR, and now he's on C status. It just makes no sense. What basically is meant to bring, have people just function in the prisons, and they're being penalized just for functioning or wanting to talk to somebody. So
I'm sorry to cut you off. Just can you complete your sentence?
My sentence is, please make sure every RVR has a reason and not just another way of being able to punitively make men and women just be destroyed within the prison system.
Your point is very well taken. First of all, I will cite back to Judge I promoted him. He deserves it. Judge Henderson from yesterday, who said that, and I fully agree with this, that prison should not be institutions of pain and boredom. I take that very seriously. That really struck a chord with me. I totally appreciate that RVRs can be frivolous. Sometimes they're important and sometimes they're not. Also, I hope that if you review our proposals, that we did our best to include trauma-informed decisions into the recommendations where they made the most amount of sense. This is something that we were also very sensitive to. So thank you very much. All right, I'm going to cut.
Just one more thing, solitary confinement. It's mental. Please read the book, Waiting for an Echo. Please
again, Delton Henderson, I think, addressed solitary confinement specifically. I appreciate that. This year, we did not deal with terms of conditions of confinement. We decided to limit ourselves to the length of punishment because we had to stop ourselves somewhere. But that is certainly, on, my mind and agenda as we move forward. So thank you very much. And then I'm going to cut the line off. But finally, Glenda Brown Wingfield.
Good morning. Can you hear me?
Good morning. Yes.
Good morning. Thank you all for your hard work and your efforts. I will be as brief as I can. My husband was sentenced under California 3 strikes. My children were 10, 12, and 14 at the time of my husband's incarceration. They are now 32, 34, and 36 years of age. He was sentenced for a nonviolent residential burglary. My husband was given a high-risk assessment. However, he has no violence in his past. I just wanted to thank you for your efforts again. Hopefully this will change. The high-risk assessment is useless, in my opinion. You cannot in 1 hour determine if someone is remorseful or not, it's very subjective. That's all I wanted to say. Thank you again. Have a wonderful holiday and take care of yourself.
Thank you. Obviously, good luck to your husband. As a result of Proposition 57, he should have chance for early parole, regardless of what this committee does. Other recommendations for this committee will also help people who are serving life sentences for nonviolent crimes. If you go to read our proposals, that concludes this hearing meeting of the Penal Code Revision Committee. It's been a long year for so many reasons. I want to say to the fellow members and staff, I appreciate you so very much. To all the members of the public, we've had a large public gathering for almost all of our hearings. Thank you. Continue to write to us. Your recommendations do not go on deaf ears. I promise you. We talk about them in our meetings and how to best address them. So thank you all. It's Hanukkah again tonight. Happy Hanukkah to everybody. Happy holidays and Merry Christmas and Happy New Year. Our next regular meeting of the Penal Code Committee will be January 13th. I will see you all then. Thank you all. It's an honor to work with you, and have a safe and happy holidays. Everybody stay safe, and we'll speak to you then. Bye. We're adjourned.